Yes, Mr. Tasty.
Thank you. Before I take you to the judgment of the trial judge itself, just to pick up, I think it was said that you'd like to see the way in which the allegations of unfair prejudice were put in the pleading. If you go, please, to page 284, you can see that at paragraph 1, the allegation is that the claimant and first defendant were joint venture partners in a joint venture. That, of course, was not maintained as an allegation as such. And then there is the reference at the end of that paragraph to the affairs of the company being conducted in a manner which was oppressive, unfairly discriminatory, and or unfairly prejudicial. And then the details of that allegation are set out. And what I would stress at this stage is the very high level at which the accusations were being put against my client, some of which were dropped fairly early on in the trial, others of which were maintained. But this is relevant when one considers the very limited reasoning from the trial judge as to why he chose to accept one particular piece of evidence. And the friend has identified some of the pieces of evidence on that, but makes absolutely no reference to many other points of evidence that was put before him over 25 days. This is an extremely short judgment compared to the amount of evidence that was given over those 25 days, even taking into account that translators were used. But you can see at 284, paragraph 2.1, these allegations are being advanced in the pleading: misapplication and misappropriation by Madame Kwok of the funds of the operating subsidiary, including substantial sums in advanced and paid by Germain to companies related to Madame Kwok without any proper justification, and other serious irregularities and improprieties. Over the page, the failure to keep proper and consistent accounts. 3, the alienation of shares in the subsidiaries by nominees of the company and or its wholly owned subsidiary Strong Nation to third parties for an improper purpose. 4, alienation and by the company and subsidiaries to third parties for an improper purpose. There is then a reference to the cooperation agreement. There's then a reference to a loan contract, the 128 million. And then if you look, please, at the bottom at 9, in breach of an agreement or understanding giving rise to a quasi-partnership. Alternatively, in denial of the reasonable and legitimate expectation of the claimant arising from the circumstances in which the company was formed between the claimant and the first defendant. And then a reference to exclusion from management and control, indeed any involvement, and then a reference to the failure to notify about important decisions. And then 4 years after the proceedings were launched, you can see at 3B in green, alternatively...
Sorry, mine's not in colour.
Oh, sorry, it's 3B. Do you have 3B in the middle of the page?
Yes, but I suspect there are possibly different colours involved even within 3B.
Oh, yes, that's right. Well, not within 3B, but certainly within 2 there. But then 3B is added. Alternatively, the claimant seeks the appointment of a liquidator on the following grounds. As set out in more detail in paragraph 15, the claimant advanced the sum of 160 million by way of a loan to Strong Nation to provide initial finance. This is the 2045 contract point that's brought in. But I would make the point that it takes 4 years for the petitioner to amend her pleading to complain about this transaction in the way that she does at 3B. The point that I'm seeking to emphasise at the moment is the very high way in which the petitioner made accusations against my client of wrongdoing and improper behaviour and effectively, to all intents and purposes, theft of assets belonging to the business. And again, just before I take you to judgment. And just because it's a convenient way of seeing the references, to see some more of the evidence that was given by the petitioner and her husband, if I could ask you, please, this is the closing submissions that we advanced before the trial judge, which I hope begin at page 3058. But we were at pains to point out what we describe as some of the extraordinary or fantastical accusations that were being advanced by the petitioner and her husband in their evidence, none of which is touched upon by the trial judge at all. So, for example, if you go to page 3072, I hope you can see in bold print some of the evidence that was being advanced by the petitioner. You can see, and what these references, so for example, these 8/72, 8/89, that's day 8, page internal page 89. If it was helpful, we could provide the cross-referencing in the transcripts that you've got here. You can see, for example, at number 11, the petitioner saying, I already told you many times, my husband, Mr. Dong, is in charge of decision-making. Madame Kwok was entrusted with daily operations. At number 13, Mr. Dong, Mr. Wei said himself, I'm the primary operator and decision-maker. Over the page, having described himself as the boss on several occasions, or rather Madame Yao having done so, said at number 18, can you point, Madame Yao, to one piece of paper in all these bundles, just one, where we see your husband between 2005 and 2011 addressing matters of management and exercising control and making decisions? Can you just point to one document, please? And number 19, I asked, can you tell me 3 things that you did as a boss? And there were no answers. And then finally at 21, we just recite the evidence that was being given by the petitioner and her husband. And there's various references there. I won't read them all, but you can see what we say was the extraordinary nature of the accusations that were being made. The hotel involved investment and decision-making. Those 2 things were done by myself and Mr. Tung. Madame Kwok never attended. She only does things to our order and instructions. She only did the daily operation. So Mr. Dong was
Whose evidence is this supposed to be?
This is essentially Mr. Dong's evidence saying that he was in charge together with Madame Kwok's husband to the exclusion of Madame Kwok. The point that I'm stressing is that much of the evidence that was given by...
Mr. Dong? Mr. Tung? Is that
Mr. Tung is the husband of Madame Kwok, and Mr. Wei is the husband of Madame Yao. But the point that I'm seeking to make by those references is that there was a huge amount of evidence which we were exploring as regards the kind of accusations that the petitioner was advancing. None of the answers that she gave to some of the extraordinary assertions that she made about her involvement and level of involvement, of course, against what was at one stage an accusation that there was a quasi-partnership. None of that was touched on by the judge at all. He didn't in any way explain why it was that he was able confidently to accept her evidence on one piece or one issue about providing information, whilst at the same time she'd made such extraordinary accusations elsewhere. And none of that is touched upon at all. I'll come back to that point, because we were stressing, of course, at the court below that the absence of reasoning or the absence of reference to a mass of evidence was particularly material. But if I could just go to the judgment then itself, because it's important to try to see the context in which the judge decided that it was fair and proportionate to make a liquidation order. So this is back to page 149. At paragraph 6 of the judgment, he refers to the claimant's allegations. And it is important, this is taken, I think, from paragraph 14 of the statement of claim which my friend took you to. It is important to see the way in which it's put at paragraph 2 of paragraph 6, subparagraph 2. Promptly notify the claimant and discuss with her any major decision, transaction or dealing affecting Crown Treasure, particularly those which have a material adverse effect on the claimant's investments, ownership and control, and similarly not to make any decision or enter into any major transaction, particularly those which will have a material adverse effect on the claimant's investment. Then he talks about the position of Madame Kwok at paragraph 7. At paragraph 8, he deals with the personal relationship. And you can see that really the relationship is one between the two husbands, Wei and Tung, that he refers to. And you can see the the final paragraph, sentence on that paragraph. During the time of the public listing, the families developed a social relationship, though not a close one, but close enough for them to pay a social visit to Madame Yao after the birth of her second child. Then it talks about the previous dealings between the two husbands, and this is how one gets to the 160 million payment. At paragraph 12, he refers to the oral agreement in respect to Fuji. And if I could just read this. This oral agreement to which he refers, the Fuji oral agreement, was what the defendant says led to Mr. Wei owing 150 million on the successful listing of Fuji. And in order to have half of it paid off, Mr. Tung agreed that of the 160 million that was needed to be paid in for the capital of the project, 80 would be credited to the defendant in part payment of the 150 million debt. I think that's the first time the trial judge uses the word capital. What you never see in our submission is any clear indication from him of what he found was the nature, as between the Madame Yao and Madame Kwok, the nature of the investment of the 160 million. Madame Yao had argued that it was all her money. The judge found against that and said it was 50-50. But she had argued that it was all repayable on demand. It was merely a loan. And it's not particularly easy to discern at all what conclusion the judge reached about that.
But it was repaid.
No, that's the 128 million.
Oh.
The 160 million, and this is why this is important on the 2045 contract, as I'll show you in a second. The 160 million is used to fulfill the obligation of Xiamen in China to comply with obligations under the land contract. And the judge doesn't actually identify what the nature of the payment by Madame Yao and Madame Kwok was in respect of the 160 million. And that's quite important if you're going to say that she's been kept out of her money for 40 years. Because he didn't appear, to us at least, to conclude that that was actually a loan. It was actually an investment into the company, giving the company those funds to enable the company then to acquire the land itself. Then he goes on to talk about the Fuji again. He then picks up at 16 the initial, some of the initial allegations that were being advanced. And then he notes, but he doesn't comment on the fact, he notes at 17 that she drops the claims that she'd been excluded from management, that she'd been denied involvement in the sale management, and that my client had failed to maintain proper or adequate records. His only comment seems to be that just reduced the amount of time that would need to be taken. But such serious accusations and allegations that were being made and then either dropped after she'd been cross-examined don't appear to receive any kind of adverse finding from him at all in the overall context of having to make a decision when there are two competing claims, as it were, on an important issue. Then you've seen this at some length in terms of the cross-examination. And this does appear in our submission to be cross-examination as to the, what I'll call the investor level type duty to notify and consult. Then at paragraph 20 he goes on to deal with the law, but doesn't, it might be noted, make any reference to the law on liquidation. He seems to be merely talking about unfair prejudice. There is then a short reference to, in general terms, the witnesses. And then at paragraph 36, he comes on to the failure to give information. So paragraph 38 says the claimant says that the defendant withheld from her information she should have been given, and which, had she been provided with it in advance of various transactions instead of months and years afterwards, might have averted the breakdown.
Can you give us a page? No.
I'm sorry, this is 165.
Thanks.
Paragraph 38.
Thank you.
And you can see there that one of the complaints that she makes is about the 2045 contract, which he comes on to in a second. But he notes that she's been aware of that from the 2nd of August 2013, but raised no complaint for 4 years. At paragraph C, the cooperation agreement, well, the cooperation agreement was made on the 9th of June 2009, and she was aware of it in early 2010. But again, that doesn't appear to have any bearing on any kind of reasoning. Then you can see, with that limited view, at paragraph 41, the requirement to give information is not solely by the Articles of Association. There are other factors, such as the initial arrangement. Whether in any case the information ought to have been given or the claimant ought to have been consulted would depend on the nature of the action proposed and the terms of the arrangements. On the facts of this case, there was a duty both to notify and consult. He doesn't explain there what facts he regards as being the relevant facts to reach that conclusion, or why any of the absurd, if I can put it that way, evidence that Madame Yao had advanced on oath, which was hopelessly exaggerated, doesn't have a bearing on this important point. He then starts at 42 to deal with failure to match funding. But he doesn't clarify at any part of his judgment here or elsewhere what conclusions he was reaching in respect of the 160 million that was used for the 2045 contract. He says, he uses the word capital and on-demand loans from time to time. And then at paragraph 45, he deals with 128 million, and he clearly does conclude, at least in respect of that it was an on-demand loan. But he also acknowledges, of course, that had been repaid in early 2010. That's paragraph 50. It was repaid from another loan in 2010. And that's what leads him to say that so far as there was any mismatch between monies advanced at 54, paragraph 54, it was only between 2005 and 2010 when it was repaid. You can't tell from the judgment whether, in fact, this mismatch is a ground on which he relies upon for the purpose of saying the company should be placed into liquidation. But any mismatching, so far as it occurred, was rectified by January 2010. And then he starts to deal with 160 million. Paragraph 55, the claimant states, in addition, she invested 160 million. Well, you would be forgiven for not appreciating that these 4 paragraphs, and in particular paragraph 58, I find that the 80 million was contributed by the defendant, so this 160 million was 80 million each. I think that probably took up 4 or 5 days of cross-examination to get to the point that there was this Fuji oral agreement between the two husbands, whereby my client's husband was owed 80 million by Madame Yao's husband. But you'll see at paragraph 57 that he says, I find that the 160 million was used to capitalise the landholding company in accordance with the requirements of the Chinese authorities. And we know that. We know from the land contract that the company had entered into to buy the land on which the hotel is placed, is that there was an obligation to provide to ensure that the company had capital of 160 million. And so he's acknowledging there that that was a commercially required and justified transaction that took place. So far, we've not seen anything about consent or veto. That's another way of putting it, that Madame Yao had a power of veto. But then we have a heading under C, failure to notify the claimant of and obtain the claimant's prior consent to another major decisions, transactions and important matters. So the word consent has now come in, but paragraph 41 didn't deal with consent when he said there was a duty to notify and consult.
Sorry, Mr. Shasty, I can't quite follow what the submission is that you are making, because paragraph 41 is the finding of the duty. Paragraph 45, then the judge goes off to deal with another duty, the failure to match fund. Then he comes back to the breaches. And what's wrong with that?
Well, he hasn't said yet where the duty to obtain consent comes from. He hasn't explained how he's found that there was an obligation on the part of my client not to go ahead without consent. He said there was a duty to notify and consult, but that's one thing.
Yes.
He's not yet explained where there is a duty to secure consent before.
Well, that's your point about the reasoning of the last part of paragraph 41, isn't it?
Yes, it is.
Well, we're not going to actually find the answer to it in the later parts of the judgment.
Well, no, my point is, though, that he now moves on almost seamlessly.
Why does he doesn't need to go that far, because there wasn't any notification or consultation,
No.
so clearly there wasn't any consent. What she was complaining about, Madame Yao, is the failure to notify and consult.
So if one stops there, it's then relevant to accept that the particular transaction that I'm dealing with, because I lost on the cooperation agreement, so I'm only talking about 2045. So the complaint is that she didn't notify and consult about the 2045 contract. Now that has to be seen in the context of the 2045 contract. The 2045 contract was entered into because there was an obligation to do so with the Chinese authorities.
Well, you're jumping, you're making several
Well, that's
jumps
paragraph
there, aren't you?
57.
But
No,
Mr.
50
Chasty, I thought there was one case put forward by the petitioner, which was that she had to be notified, consulted and give consent to major transactions, including those involving investment. And as I understand it, your client denied that.
Yes, you did.
In its totality. So there wasn't a chopped up duty to notify and consult on the one hand and a further duty to gain consent. That was never part of either side's case, as I understand it.
The pleading's not terribly clear on that. The pleading at the pleading that my friend referred to in paragraph 14, on the first part, paragraph 2 talks about notifying. It's paragraph 3 that introduces the without consent part.
This is page...
Sorry, this is page 293.
293.
293 for the pleading. But my point, Lord, is that the judge...
Sorry, I mean... Oh, I see.
There's a duty to notify, and then separately says...
Well, so, I mean, I see. So you think the judge is just referring to 14.2?
It's not clear.
Not to 14.3.
It's just not clear, because all he's done in one sentence at 41...
Your client denied both of these quite clearly, didn't
Yeah.
she? Yes. All right.
My client's
Wasn't on.
position is she's in charge, she's left as and the Madame Yao is just what I think my client coined the phrase, passive investor.
Right.
But the point that I'm making is you get to paragraph 41 of this judgment, and the best that you've got, and obviously I say it's not particularly good, the best you've got is one sentence. On the facts of this case, there was a duty to notify and consult. He's not analysed the consent aspect of that yet. He's the one who's dealt with just notification and consultation. But then when you get to section C at paragraph 59, he starts to talk about breach, as if he's already in some way dealt with the duty point and to get consent and how it arises. But the important point here is in the context of the 2045, which is really the one we're concerned about in the light of the Court of Appeal's decision, is at 57, the finding that was a commercial necessity to capitalise the company because of the Chinese authorities' regulations. And you can see again in a second what the judge says about that.
But isn't the point that, yes, you needed to capitalise it, but if Madame Kwok had consulted with Madame Yao, they might have found some better way of doing it rather than entering into this very onerous agreement that put off any ability of either of them to obtain anything out of this for 40 years. Isn't that what the judge was saying?
That was never argued because the land contract, from recollection,
obvious.
doesn't allow for negotiation. It is an obligation to capitalise the company for that period of time.
Yes, but it's a question of the terms on which the $160 million is used.
Yes. The difficulty is the judge wasn't even prepared to say, and the Court of Appeal noted this, the judge wasn't even prepared to say that Madame Yao would not have consented. We just don't know whether... She wasn't even saying, if I'd been consulted, I would have withheld my consent.
She didn't want to have to prove that.
Well, but it's a difficult... If you're going to complain about... In our submission, if you're going to complain about a transaction which we say had to be carried out, and you're going to say you didn't notify me in advance, but you're not prepared to say, and I wouldn't have consented to it, I would have stopped it happening. If that's not your case, that we submit is highly relevant to then the decision to liquidate. If you come along as the petitioner, and you say, well, my complaint is not the decision itself. If you look at that, please, it's paragraph 66 of the judgment. So this is page 172. And first of all, you've got 65, paragraph 65. There's a reference to the loan contract being commercially necessary to be viewed in the light of the land use contract of 2005 entered into with the German authorities to acquire the site. In particular, the loan contract 2045 satisfying clause 18, which within 2 months required the establishment of a project company with a registered capital of 20 million US, which is the 160 million. She stated that the loan contract was made to satisfy the capital requirements of the project. And of course, this is an equal contribution by both of them on this analysis. But then at 66, the judge says the actual...
Well, the last sentence, though, is the important bit, isn't it?
Well...
It's the lock-in.
You
borrowed the money, but you didn't have to borrow it on those terms.
Well, that, with respect, was pure speculation by the judge. That was not being advanced about that point. Because...
Well, it's intelligent speculation, Mr. Chasty.
Well, it wasn't something that was being advanced by the claimant.
It doesn't
I
matter.
thought the previous sentence, he does seem to record that, doesn't he?
Well, no.
Maintained that locking her investment in 45 years
not
was
necessary.
not necessary.
No, her position was that this was an on-demand loan, this 160 million, of which she had of which she owned all of it. And whereas...
Yes, but it's the terms on which the loan was made to Strong Nation, was the matter.
Yes.
Which wasn't an on-demand loan.
But there was no evidence to support this rather sweeping proposition at all here.
What? That
There was some other way of finding the money, and it wasn't going to be the 160 million. And 66...
all that is being said is that she complains about it.
She complained about it, absolutely she complained about it. The principal basis on which she complained, of course, her complaint was this was a loan, which she was making, a loan, and she could recall the loan at any time, and by entering into this arrangement, she couldn't now recall the loan. I put during the course of argument with the trial judge, well, we said it wasn't an on-demand loan, and I think the judge agreed with that, but I'm not sure. We said, why didn't she ever ask for the money?
I'm getting a bit confused.
Well,
which loan is on demand or not on demand?
the difficulty I'm having is the judge doesn't tell us his view about that. The 128 million is an on-demand loan,
Yes.
as far as the judge is concerned.
Yes.
The 160 million, I'm afraid I can't answer the question because the judge doesn't tell us.
But it doesn't matter for the matching funds purpose because he decides that it was actually matched.
Well,
So
it matters to this extent. If the 160 million was being advanced equally, 80 million each, to give to the company as its funds, then there was no materially adverse impact in our submission on Madame Yao because she was giving the money to the company to use. If it was a loan, then she might have been adversely affected because the funds weren't going to be there should she ever choose to ask for the money back.
You're talking about the loan to Crown Treasury?
Yes.
It was a loan, wasn't it?
Just
It wasn't capital, was it?
I'm sorry, I just can't answer your question. We said...
Well, it wasn't put in for share capital.
No, it wasn't put in for share capital.
So you
no.
say it may have been a capital contribution.
Exactly. And because the company needed funds, and it wouldn't have made sense, was part of our argument, that you would put in an on-demand loan when the company might commit to buy the property, and Madame Yao or Madame Kwok, for that matter, might have a change of heart and ask for the money back.
That's totally unrealistic as a matter of commerciality, Mr. Chasty.
But it is, and that's why we said this was not an on-demand loan.
But what rather putting the point the other way?
I understand that, but we put the argument that this couldn't, as the petitioner was maintaining, be an on-demand loan. There's no guarantee that these two ladies wouldn't have fallen out very quickly and engineered whatever tactical position they might have thought was to their advantage.
I'm sorry, Mr. Chasty. I'm sure it's my fault. I'm just not quite sure of the overarching submission you're making, of which this forms part. I mean, in truth, I'm not quite sure whether it matters whether it was an on-demand loan or not.
We say, sorry,
I
we say it
quite
doesn't...
see. I mean, the complaint, as I understand it, in relation to this, is that Madame Kwok, without reference to Madame Yao, determined the terms on which Crown Treasure put the funds into Strong Nation.
Yes.
And, I mean, you accept that she wasn't consulted, but you say there was no obligation to do so.
Correct. But I then make the point that in order to get to the liquidation remedy stage, you also need to, we say, consider why that was done.
Yes, but unless you're saying that, advancing the argument that the only basis on which the judge could order a liquidation was by reference to this loan or this transaction, this is just one of the transactions which goes into the mix. I mean, you may well be right that on its own it couldn't possibly have justified a winding up order.
Right, and then if you then look to see what else is left to justify the liquidation, you've got mismatching, it said. Not quite clear what analysis the judge gives about that, but we know that it was, in any event, reconciled at the beginning of 2010, 7 or 8 years before his decision to put the company into liquidation. If it's the cooperation agreement, we know that Madame Yao knew about that in early 2010, again 7 or 8 years before he put the company into liquidation.
But I'm quite sure. So what follows from that no relief should have been given?
I'm sorry?
You're saying that no relief should have been given because it was a bit stale?
I'm saying that certainly no liquidation should have been imposed on the company after that length of time in the absence of any complaint even for a very long time. And I go back to what I was trying to... can I just make the point about 66, because you can see it there, paragraph 66. The actual decision per se is not necessarily being criticised. The defendant was allowed to make management decisions. What is being criticised is she didn't consult. But the judge later goes on to say, and I'm not going to decide, and I'm not going to find whether, in fact, if she'd been consulted, she would still have consented. But to take my Lord's point, yes, that is one ground, and obviously I'll need to deal with ground one of my friend's appeal on the 2045 contract. But we say the 2045 contract, on the judge's own analysis, appears to have been it was a necessity to capitalise the company to meet the Chinese authorities' requirements. It is a management decision, he said at paragraph 66, and the decision itself is not as such being criticised. All that's being criticised is that Madame Yao was not consulted. But in the same breath, Madame Yao won't tell us whether she would or she wouldn't have consented if she'd been asked.
Well, I can see your point if it was a one-off complaint.
Yes.
But taking the pleading and the evidence as a whole and the way the case was presented, in a nutshell, the case was I entered into, or I thought I'd entered into, we agreed, a relationship under which all major decisions and transactions would be subject of notification, consultation and consent. And what actually happened was that Madame Kwok went off and undertook all these major transactions without any notification or consultation or consent. Now, if that's the gravamen of the complaint, it may not greatly matter that, with hindsight, the complainant can't remember in relation or can't decide or isn't sure in relation to just one of them whether she might or might not have consented. Well, what she says is that what followed from this was all the dilutions.
Well, the judge says the same.
One of which was still in place when the judge was being done, when the judge was writing his judgment.
The judge says the same about all of these transactions, though, at paragraph 91, at page 178. He says it about the others at 91. He says it's not open to the court to speculate on what Madame Yao would have agreed to had Madame Kwok informed her about the terms of the private non-bank loan from Cheer Fancy, or the cooperation agreement, or the shareholders agreement. So he doesn't just limit it to the cooperation.
What he says, and what matters is, she wasn't given the opportunity to be heard on it.
Quite.
And she had a right in equity, he says, to that information in line with the business arrangement concluded between the parties. No doubt referring back to equitable considerations of the Westbourne Gallery's type.
Well, the only one that he's identified so far as having found that there was a duty is the duty to notify and consult at paragraph 41. That's that last sentence at paragraph 41. That's the extent of his reasoning to justify that against the background, I repeat, against the background of a whole host of allegations that were being advanced against my client, that were either dropped when it was realised by counsel in closing submissions that he couldn't seriously pursue them, or at earlier stages. None of that reasoning none of that evidence was referred to. And so, just stopping from the judgment for a moment, just dealing with this 2045 point on the evidence. So you have this very limited amount of evidence that my friend's been able to refer to on this point, in respect of the 2045 contract, because I appreciate I'm stuck with the cooperation agreement from the Court of Appeal on the duty to notify at investor level. But the 2045, we say, is not an investor level transaction. It doesn't per se dilute the shareholding of Madame Yao. It ties, we say, the company's money up, not her money, the company's money up for a period of time, for a long time, but that's what was required in order to secure this land to build a hotel on. So on this, we say that there is no adequate reasoning and there is no evidence on which beyond that very limited reference from a friend. I think just to give you give the reference where I did cross-examine Mr. Way to similar terms to the cross-examination of his wife. I won't take you to it, but it's page 5492. It's 5492 in the transcript, where I put those points about the way in which she had expressed herself in her witness statement. He had put himself in his witness statement. This would have done something. She would have had to do X, Y, and Z.
So are you accepting then that there was evidence from which this judge could, had he explained himself more fully, have reached the conclusion that the cooperation agreement was in the terms that Madam Wei and her husband said, Madam Yao and her husband said it was?
Well, the Court of Appeal has found against me on that, so I have to accept what they say.
On a limited basis. What I'm putting to you is the wider point.
Sorry,
I think you're across purposes. My lady referred to the cooperation agreement, but I rather think you meant the main agreement.
Sorry, I meant the main agreement.
Oh, sorry, the 2045 contract.
No, the original 2005 arrangement between them.
So, is there any evidence of a duty to consult and notify? Well, the best there is the paragraph in the statement of claim where that allegation is made, and where those words are replicated in the witness statements in identical terms, the evidence of Madame Yao and her husband.
And the cross-examination, I thought that, sorry, it's probably that I am at cross-purposes with you, but I thought you were giving us the references to where you put the same points in cross-examination.
Yes, that's right. I did cross-examine them to make the point that they had not, and in order to identify with the judge, that they had not gone so far as to say or give any particulars of there being an agreement to notify and consult. It was put forward as a conclusion, as it were, or an assertion, but it wasn't put forward as there having been any underlying agreement to do that. And Madame...
So your point is that there isn't even evidence in chief to support the suggested, I won't say pleaded, the suggested agreement.
Yes.
Is that right?
Not the way in which, exactly. It's they would have had to do this, but there are no particulars of the agreement said to have been arrived at, or when, or where, or how. And I was
a point of the way that the witness statement is phrased. I'm not saying that's a bad point to take. It may be a very good point to take, but it's that actually they do not themselves provide the evidence to support the allegation of an agreement.
Correct. And I deliberately stressed in cross-examination, there was no suggestion that there'd been any nuancing in terms of translation. There were enough English Chinese-speaking lawyers involved in the case for an objection to be taken to say there's been an error in the translation of the Chinese version into English. I was at pains to point out that it had been a deliberate decision had been made to provide a witness statement which was expressed in those terms of what would or what was required to have happened. And so I stressed in cross-examination.
I'm not entirely sure I've got a grips with what the distinction you're making. You were saying that the way that it was worded, they weren't saying that there was an agreement to do it. They were saying, she was saying that they would have had to do it.
Effectively, that was at best their belief.
And then you put that to her, and she said, I don't accept the point you're making. I said, didn't she then reject that as a reading, a proper reading? And she was saying, no, it was not some carefully worded thing. There's no difference between those 2 points.
Well, I think that's when she accused me of majoring in literature rather than law.
Yes.
Yeah. That's about as far as it went.
What was the source then of what she was saying would be their obligation to do something if it wasn't an agreement to do it?
It could have been her mistaken belief or her unjustified assertion. She made so many accusations against my client. That's what I've been at pains to try to point out. She made so many sweeping allegations against my client. my point to the judge really was, look at the way in which they expressed themselves on this important point, and then balance that against all the other extraordinary accusations that they've made.
But surely the judge was entitled to say, well, I accept her evidence in response, which is that this is mere linguistic sophistry. And actually what I was saying was that there was an agreement.
Well, he doesn't say that, of course. That's part of the problem.
I mean, you're
He doesn't say
inviting
that.
us
There
to
was no re-examination.
You're inviting. Well, I think she did really make that point, but you're really effectively asking us to construe the witness statement and to say that it doesn't contain evidence of an agreement.
What I'm saying is, if you look at what the Court of Appeal has done in terms of its own conclusions, that there was not sufficient evidence to justify this conclusion of a duty to notify, certainly on the 2045, the non-investor level transaction, then you can understand, and I would say and agree, with why they approached it in the way that they did. I have, of course, the added problem in a sense that
So, I mean, this all turns, as I understand it, this submission that you're making, on paragraph 34 of, I think I'm looking at Madam Yao's witness statement, and that's the one where she says, in particular, Madam Kwok would have to promptly notify me, and so on.
yeah.
Now, that's all in the context, isn't it, of an earlier paragraph.
27?
27. I shall, in the following paragraphs, deal with what was discussed and the understanding and agreement reached between Wei Dong and Tung Fai at the numerous discussions.
Yeah.
But you're saying that when we get to this particular paragraph, it's not evidence as to what was agreed, it's something falling short of
Yeah, that's how we
It's a sort of textual point, and that's why you asked the questions you did.
Yes.
You never put to her, there wasn't such an agreement, was there? Did you? I mean, at least I've not seen it. If you did, I'd like to see that.
I would need to go through the transcripts again more closely to put that point to put that.
I think.
But my point that I was just seeking to make is one of the difficulties with this judgment is if you read it, you would not realise that there was 25 days of evidence, and as my friend I think has acknowledged, dealing with a whole raft of issues between the parties, in respect of which one side against the other were taking exactly opposite positions. None of that is addressed by the judge at all. None of the approach of the Madame Yao and her husband to their evidence is considered or commented on, either adversely or otherwise. And yet, on one point, he picks this up and just says, there is a duty to notify and consult. And we've got to try to look for where this comes.
Is that altogether surprising? What the judge had to give a judgment about was the complaints that were still being pursued at the end of the trial. And the central complaint being pursued at the end of the trial was lack of consultation, lack of notification, consultation and consent. So all the other stuff, in a sense, flies out of the window, and he doesn't have to clutter up his judgment with making findings about it.
I disagree with that, because if you've got somebody on an important point saying, I'm right on this point, but that person might have been wrong on 29 other points, the judge ought to say, in our submission, why, having been wrong on 29 points, he prefers her evidence on this one point.
Okay.
But we can't find any clues from that. And I did seek to argue in the Court of Appeal, I should stress, that the judgment itself was bad and should be overturned. Whether that had a consequence of going back on a retrial would have been a matter for debate. But the judgment was so bad with respect in its complete lack of reasoning that on the authorities, that was a self-standing ground of appeal in itself. Now, the Court of Appeal said they didn't need to consider that. Now, my Lord, there is a case that was before you that I appeared in rather briefly extremely briefly in fact, which did raise the question of concurrent findings, which this is obviously not one of, but it did also raise the point about absence of reasons. That was in a different context because, of course, the Court of Appeal in the Sankas case that I appeared in the Sankas case decided the issue and said, we think the judge gave adequate reasons. I tried to, in the time I had available, to argue that didn't fall within the principles of concurrent findings and that I could still have a ground of appeal in the absence of reasons. Now, obviously, you were against me on that, but I don't think with respect that the reasons necessarily for the dismissal of my appeal has yet been circulated. But
no, they haven't been.
No, but I would say there's a very important distinction here. In circumstances where the Court of Appeal hasn't considered the point as to the inadequacy of reasonings, then it's something that's still at least not going to fall within any obstacles of the concurrent findings type of position.
It's just a sort of respondent's notice point.
Well, I raised it as an additional ground. It's not really a spot. They just didn't. They just said they didn't need to consider it.
I mean, that's obvious, isn't it? Really, yes.
Yes.
Yeah.
But if you go back to paragraphs 31 and 32, just pondering on what you've said.
Of the judgment.
Yes, on page 163.
Yes.
You make the forensic point that the judge hasn't looked at, the 29 other examples of where they're in the wrong and weighed that in the balance.
Yes.
Well, he hasn't done it in terms, but when you actually look at his assessment of the witnesses, he's made two basic findings. One is that they were sometimes unreasonable in their disputation in cross-examination. In other words, they said things that were not reasonable. And that they were fueled by a passion.
Yes.
But then he also says, I formed the view that they were basically honest. The passion clouded their responses, right? But also he found that these are honest witnesses who felt they'd been gravely wronged.
Yes.
Now, why isn't that an explanation for why witnesses might give evidence that turns out at the end of the day not to be accepted? They're looking at it from a distorted perspective of feeling that they've been gravely wronged, and therefore they put the wrong slant on everything. But they're basically honest people, so they're not actually lying about what happened. Now, from that perspective, it seems to me that he's probably done enough.
Well, I would say it's too general. He hasn't done enough in our submission. It's far too general. You have to look at the accusations that they were prepared to advance against my clients and then just drop. They were accusing my client effectively of theft, misappropriation.
At this point, it depends on them balking at saying in their witness statements that there was an agreement when there wasn't, and instead using some sort of weasel words that falls short of that accusation, whereas you say they were prepared to make all sorts of wild accusations about things that they then dropped.
The allegations were wild. They were fantastical that were being put in the context of the obvious facts that existed. That went beyond passion. That was a willingness to advance anything that they thought, however misguided, might apply pressure to my client and advance a position.
Well, that's very close to finding dishonesty, and the judge has decided that they were basically honest witnesses.
But what he doesn't do is he doesn't explain anywhere, he doesn't address all of these accusations and all of the evidence of points that were made. And I say, in the context of this important point, to say, which seems to be, I'm going to base a liquidation order on a finding of a duty to notify and consult, which I find has been broken. I'm going to make that extremely serious draconian decision. I'm going to sign the death warrant on Crown Treasure based on one sentence of a duty to notify and consult.
This is, I do think you're slightly confusing or conflating two quite separate points. The first point is, was there that duty?
Yeah.
And that's a binary question. On the balance of probabilities, having regard to all the evidence, there was or there was not the duty. If there wasn't the duty, end of case. If there was the duty is established. And you then go on and breached in a number of respects. And in the light of those findings, the court has to decide what is the appropriate remedy. It doesn't revisit its findings of fact and say, well, they were pretty evenly balanced, and therefore I will
I think,
order something less than I otherwise would.
I think I was.
These are quite separate.
I think I was making two points as one there. I am saying that there was a separate ground that we were seeking to advance in the Court of Appeal about the absence of reasons to justify the conclusions that were being made.
Yes.
And the difficulty with this judgment, and it runs throughout it, is that failure. It simply does not, in our respectful submission, meet the basic standards required of a judgment. I repeat again, you would be, apart from him saying, oh, there were lots of claims being advanced, but they've all been dropped, beyond that reference, you would not have any real inkling or understanding of the range of issues that were being advanced by Madam Yao.
I mean, if you were to succeed on that, the case would have to be remitted for a new hearing.
I understand that.
Yeah.
That would be a far preferable position for my client than liquidation. Just going on with the judgment, it is difficult. So we've had the heading of consent at just above paragraph 59 at C. Then at 68, paragraph 68, it picks up with the cooperation agreement. Then at 77, it says that on the cooperation is a clear breach of the arrangement not to make any major decision or enter into any major transaction. And I lost in the Court of Appeal on that. But then if you look at 80 on this, I find that there was funding in place, but the defendant made a management decision of which prima facie the claimant can't complain. The claimant's valid complaint lies in not having been consulted. So, again, a management decision by my client, who is entitled to make management decisions. All those allegations of quasi-partnership and a right to have a say and be involved in the management were dropped. So she can't complain about my client making what is described as a management decision, but then it said that the complaint lies in not being consulted. And then I've made the point already that he says he's not going to speculate as to what the outcome of consultation would or wouldn't have been. Also, of course, the next point, the Eng loan, at paragraph 83, the 128 million, was repaid from the Eng loan, and he doesn't make any reference to that subsequently. Then we eventually get...
I'm getting quite lost here again.
Sorry.
Paragraph 80, he's talking about the cooperation agreement.
He is.
Right.
He says that that's a management decision of which prima facie the claimant couldn't complain.
Well, as I read it, he's saying, viewed from the perspective of whether it's good or bad management, it may be perfectly all right.
Yes.
But because it had the consequence of dilution, and it was in breach of the obligation to notify and consult and obtain consent, and was a breach of that agreement, it was unfairly prejudicial conduct. What's wrong with that?
Well,
it's a classic example of what happens in a corporate situation where if you just look at the company's rule book, it seems perfectly okay, but once you insert the equitable considerations which are grafted on top, then it doesn't look okay anymore, and you get equitable relief.
And I've already lost in the Court of Appeal on that. I accept that. The point that I would stress, of course, is that goes back to 2010. That's the transaction that took place in 2009, in fact. and the claimant was aware, the petitioner was aware of that from January 2010.
Is that a point that features in the Court of Appeals judgment?
I don't think it does, no. But it doesn't feature in this judgment either. It doesn't feature in the trial judges. He takes no account of he doesn't take any account at all of the age of these transactions of which complaint is being made. What he does then is he then comes to the summary.
So that's a submission that goes to the appropriate remedy?
Yes.
Yes.
And I should just add while making that point, that the Court of Appeal said that the liquidation order shouldn't stand, and it imposed the provision of information order in its place. I've forgotten exactly how long ago that was now. It's 3 or 4 years ago, I think. And there's not been any renewed complaint about that not being met and observed. Madame Yao has not complained that she's not, as far as I'm aware, been told if I'm wrong, that she's not being given information pursuant to the Court of Appeals order. It was said it wouldn't be possible to police or manage it. Well, the proof is, in fact, that
Are you making an application to adduce fresh evidence?
No, I'm just saying that is being in place. It's just worth making the point that. So can I just then come to summary? Because the reasoning is quite difficult to follow in terms of how we got to the liquidation order. There just seems to be a whole host of factors that possibly being thrown into the equation. So he starts at 88. The picture painted by the evidence is that Madame Kwok, who according to the evidence didn't even have a job when they met her, largely with the claimant and Mr. Wei's start-up money, is and will be enjoying all the benefits and power of a sole director, a salary as a general manager, and all the economic and social prestige and perks that go along with its ostensible owner, while Madame Yao has nothing and can only watch with her nose pressed up against the window pane. That's something that was mentioned during the course of argument. There's a number of points there. By this stage of this analysis, the Madame Yao has been repaid her 128 million, and the 160 million has been contributed in equal shares, 50-50. To refer to Madame Kwok, enjoying all the benefits and power of a sole director salary, no complaints about that at all. There was never any. This was not a petition based on any accusation of non-payment of dividends that ought to have been paid, or avoiding the payment of dividends by making payments of an unreasonably large salary to one person.
But the complaint of unfair prejudice was never that Madame Kwok was managing director and being paid a salary.
No.
The complaint of unfair prejudice is how, against that background, the treatment of Madame Yao was unfairly prejudicial.
Well,
and you also have to factor in the fact that although the 128 million was paid back, it was paid back on the findings of the judge, which were undisturbed by the Court of Appeal, of a blatant misrepresentation as to why the loan was required that was actually used to fund it.
When you say a blatant misrepresentation, there was no finding as, I don't know if you mean by that anything other than a misrepresentation. There was no finding of impropriety. It was not a finding of anything such as fraudulent or anything other than, at best, well, again, he doesn't analyse it, but it was not a finding of impropriety in terms of the misrepresentation.
In the context of somebody who's under a duty to notify and disclose and consult and obtain consent, it is quite blatant if you don't.
Well, it's an error. It is an error. It depends whether or not. Yes, it's an error. But again, the difficulty is that you don't see any real analysis as to the level of that the judge reaches as regards that finding of misrep in terms of that. Again, I make the point that you can see from 84 that Madame Yao was aware of that issue early in 2010. Then you can see at paragraph 91 the judgment, this is 178. I've already referred you to this. He's not going to speculate, but we say this is a rather important point about what might have happened. So he's not finding either way. He's certainly not finding, therefore, and it wasn't Madame Yao's case, that she wouldn't have consented to all of this. She wasn't prepared to say. Of course, we had a massive evidence about the commercial necessity to enter into these transactions, including the cooperation agreement, including the Eng loan.
Right, okay.
We had a massive evidence on that, and I was putting a massive evidence in cross-examination. I'd have to get the pages for you if you want them, that there'd been meetings where Madame Yao had given what we referred to regularly during the course of the trial as the green light because of the difficult financial circumstances that the company was facing. But none of that features anywhere in this judgment. It's just forgotten about. It's just not mentioned at all. You just have this...
There was a pressing commercial necessity to repay Madame Yao the 128 million, wasn't it?
It was our case that Madame Yao was told that the 128 million was for that purpose.
No, I'm sorry, the finding upheld by the Court of Appeal is that she was told something quite different.
On the misrepresentation, I agree.
Well, but that's all the same. You said there was a pressing commercial necessity to borrow the 100 million from Mr. Eng.
Sorry, I wasn't being clear. I was focusing on the cooperation agreement in particular. There was a massive evidence about the necessity, given the bank's refusal to advance funding.
Okay.
But none of that, again, is dealt with. There was...
Yes, I see.
There was a massive cross-examination and evidence about the need to enter into that.
Yes, but
it doesn't feature anywhere.
I mean, the point here is that if consulted, Madame Yao might have had something to say about the terms on which the funds were being borrowed.
I agree. But the judge just stops and says, I'm not going to speculate any further than that.
Yeah, I see.
And she didn't advance any positive case as such to say, I would have refused that. The judge just doesn't make a finding. He says he's not going to speculate.
She didn't assert
I have no...
that she
I'll be
would
corrected
not have consented. Did you assert she would have?
I'd struggle to.
You can't really criticise the judge for not making a finding on something that neither side is inviting him to make a finding on.
Well, if it's
and
more...
a hypothetical.
Sorry?
And a hypothetical. It's not even a concrete
it is, but it's more relevant, I would submit, that if somebody's going to say, you owe me a duty to get my consent, to say what the consequence would have been if we'd sought it.
Well, doesn't that, I mean, in practicalities, if every time there was an allegation of a breach of the duty to notify, you could only be entitled to some kind of relief if you could show that had you been notified, had you been consulted, it would have turned out differently, then that opens up a whole other areas of evidence and retrospective examination of the commercialities that not really relevant to the breach that's alleged.
Well, I'm viewing it in the context of the decision to make a liquidation order. You're making a liquidation order, having said there's a duty to notify and consult, but I'm not finding that would have made any difference at all if you'd done that.
But it might in the future, on another occasion.
And therefore make sure that in the future going forward you notify and consult. And that's what we're going to order you to do as the Court of Appeal.
I mean, I hope you don't mind me. May think I'm being unduly cynical, but that entirely depends on Madame Kwok abiding by it, and Madame Yao may never know whether some transaction has been entered into on which she should be consulted.
Well, of course, that's right. But
I mean, she's a bit of a serial offender on this.
Well, there's a court order saying you've got to do it. So...
well, she enters into a transaction in the PRC in relation to the hotel, which is a major transaction, but it may never come to Madame Yao's attention.
Well, I wouldn't invite you to reach a conclusion that she's going to breach court orders. If a court order was made on that, that would be a different point. It's an entirely appropriate order to make, as with any.
Well, I'm not saying it's not an appropriate order to make.
Yeah.
You have to show that the winding up order was a wholly inappropriate order, which no reasonable judge on this basis would have made.
Exactly so, and that's just to follow this through then. He then at 96. He says, whether a passive investor, whatever that may mean or not, I find that she was entitled to the information. He then, you can see at 99, this is coming back to something that I was talking about earlier. At 99...
Well, just before you go on,
Sorry.
you said the judge never considered the fact that these transactions were all rather old. In fact, he does in 96, doesn't he? He says late use doesn't play a significant part in this case. Because some of the examples were only 5 months before the trial. Of course, he didn't know about the what was going on when he was writing his judgment.
Well, I'm going to come back to that. The trial balance is 5 months before the trial. That's the only point that he doesn't, of course, address the cooperation agreement being 2009. That's a reference to some correspondence that had been raised 5 months before the trial, asking about detailed questions about the accounts and management accounts.
Yeah, and not getting answers.
Correct. I cross-examined about that, and it was quite clear, and it was dropped, that there was absolutely no substance in any of those applications. And you saw from paragraph in the pleading, I think, a question about management accounts, but that was a non-point because something was raised in correspondence, making again accusations and allegations in relation to trial balances with an innuendo or an implication that there'd been some serious wrongdoing and financial gain by my client as a result. I cross-examined on that, and after cross-examination, the petitioner in their closing submissions dropped the allegation. So he doesn't really consider late fees in our submission. That's the only reference he makes, but it doesn't feature as an issue. Then at 99, he goes on to this point about alternative remedies. He says, I sought counsel's assistance on whether it was open to the court to grant a remedy other than any of the two remedies sought by the claimant, namely in order that Madame Kwok sell her shares to Madame Yao, or alternatively winding up. Mr. Chastey felt if the court was not minded to grant either remedy, it should dismiss the claim. Mr. Fisher was of the view the court would first have to give the parties an opportunity to be heard on the proposed alternative remedy. And as Mr. Chastey submitted, this would have the effect of giving the claimant 2 bites at the cherry. Having found for the claimant, in my judgment, dismissing her claim would maintain the status quo against which she has a justifiable complaint. That would be unfair. But he didn't then say, I am going to consider the alternative remedy, which is I'm going to bring everybody back and consider whether or not Madame Kwok should be required to buy Madame Yao out.
Well, because, as I understand it from the passage you just read, you objected to that course.
Well, of course, my position was you should dismiss the claim. Yeah. But it doesn't follow from that the judge is barred by me saying you should dismiss the claim, and therefore he says, I don't have therefore any alternative but to put this company into liquidation.
No, but it does put you in a difficult position when you're complaining about what he did.
Well, don't see with respect why.
In particular, Mr. Chastey, you're saying that on this, what I might call reasoning part of your submissions.
The what, sorry?
You're saying on this part of your submission about the reasoning or absence for the winding up order. Yeah. But maybe, well, if there was some justifiable complaint, the judge should have made a policing order of the type made by the Court of Appeal. But I mean, the judge sought assistance, as he says in paragraph 99, and you didn't, I think, submit to him, well, if you think there is some unfair prejudice here, you should make a policing order. I mean, ignoring for the moment the fact that the parties are in the People's Republic of China and the judge is in the British Virgin Islands, but I mean, assuming that police in theory might have teeth.
No, I don't think I expressly referred to a policing order. What I was talking about here, my lord, was the alternative share purchase order,
Yes.
where we'd had a debate during the course of submissions. The judge had asked for about middle ground, and I stated our position, which was we think you should dismiss the claim because that's the position that the claimant has always adopted. And we were saying to him, she's chosen the battleground. She's chosen an unusual order as her primary relief, which is I'm compelled to sell. She shouldn't gain a benefit from that simply because you then dismiss that claim as being disproportionate, apparently, and then say, well, the only remedy she's got is liquidation.
But wasn't this an instance where both sides were adopting extreme positions? The judge asked for assistance if he was not prepared to adopt either of those extreme positions and wanted to know what else he could do.
Yeah.
And he got no assistance.
Well, I think it's being fair to say he didn't get any assistance. He was told quite clearly, and we accepted, of course, that he had alternative remedies available to him in a range of remedies that he could choose. We simply stated that the claimant, having committed herself and put her colours to the mast of two remedies, one of which, very unusual, we said she doesn't have any real prospect of securing, shouldn't by default then get liquidation. But we didn't say, under no circumstances would we be prepared to agree to buy her out if that is the order that you make. He said he was going to bring that back if it was going through his mind. He doesn't.
He actually mentioned that as a possibility, didn't he?
He said, if you remember, I think I can give you.
Yes, I see. That's what
he said. I will bring you back if I'm going to consider doing that.
Making your client buy Madam Yao's share.
Yes. But what you don't, I'm sorry, what you don't see in 99 and 100 is why he seems not to have considered himself that point.
Well,
he can't be because my client
an
said
argument
they don't
that doesn't
really
carry you very far.
Well,
if you've not put it to him, it's difficult for you to come here and complain that he didn't think of it for himself.
Well, he did, but he did.
But what I did want to ask you is it does appear from paragraph 101 that you did make submissions about the suitability of a winding up.
I said a winding up order was not appropriate.
Now, when did you make those submissions?
Well, they were.
Was it during the trial at closing, or was it? I mean, when were those submissions made?
Well, I think they were made. We always put our position that
we were taken to. We saw what Mr. Fisher said, I think, in reply, which was when there was a discussion about winding up as a remedy. But you must have at some stage made submissions about that, either orally or in writing.
They'll be in my written closing submission.
Your written closing.
And I think, and I will have.
So it was on the table before the
table.
judge with submissions from both sides.
It's on the table.
Yes.
But you'll remember he said to me, I don't think a winding up is proportionate here.
Right.
He said to me at page 7139 of the transcript, I don't think this is a case for winding up. To which I said, I'm grateful for that.
You did.
And then matters then moved on when he had this light bulb moment when Mr. Fisher seems to have said to him, what you're winding up is the holding company, not the trading company. Yeah. To which he said, oh, that's one way that she can get the money.
That's a different way. Yeah.
I take it, Mr. Chaser, the oral submissions the written closings preceded the oral closings in this case. Yes.
When I look at the dates of the hearing at page 149, there seems to have been quite a gap between the 12th of January and the 4th of February.
Can I also make this point that one has to remember also the way that the liquidation order was being sought by the petitioner. It was even described as a collateral point at one stage by Mr. Fisher. It was so far off the radar, even for the petitioner.
But are you complaining about a failure of procedure?
No, I'm not, my lord.
Because that's what it's sounding like. The issue here is whether this was an appropriate order. I mean, how the argument went and
I was
so on,
really
I think-
seeking to put in context.
Well-
A response to my Lord's question was, did we address this in
And we
submission?
did, you did, because I had the impression that there hadn't been any submissions on it
I see.
from your side, and we agreed there were.
He's taken at 101. He's taken those references from our written closings, I believe.
Right.
Because I wouldn't have quoted those paragraphs off the top or simply orally.
So your submissions on why it was not an appropriate order, and on that basis, we should uphold the Court of Appeal's decision, even if we're against you on ground one, are what? Can I just finish on this? Because what you will then see is he deals with 101, 102. At 105, just jumping ahead to that, at 105 he says, ordering Madame Kwok to sell, as she asked the court to do, would have been a disproportionate response in Madame Yao's favour against Madame Kwok as an equal shareholder. That is only half the reasoning. Well, there's no real reasoning. There's no explanation about why it would have been disproportionate. We had put in a whole host of arguments that, and I'm repeating myself to an extent, that a shareholder who's played no part in management should not be the party normally being the one entitled to the purchase. But it doesn't matter. He agrees with you that it's not an appropriate order. I mean, there's no appeal about
No,
it.
he's not. But he doesn't say why he agrees with me. He just says it's disproportionate. But he at 104, they probably should be the other way round, really. But at 104, he says, a helpful guide through the textbook may be, and this is, of course, the usual deadlock, loss of substratum, expulsion of a working partner, loss of confidence in management. He says, I don't suppose the list was intended by Mr. Holling to be exhaustive, nor was any authority drawn to my attention that the claimant must prove that she comes within any of those categories. As matters stand, this is one of those cases, rare though it may be, where the circumstances dictate that winding up is the fairest and most proportionate response. Now, he does that
in the context of considering and rejecting a sort of supervision policing type of order. Second half of 105.
Yes. So what he's done is he said, from the evidence it appears trust has broken down, and then he touches again on the 80 million, and then he just says it's basically this seems to be simply him going back and saying it's a way of getting the money out. But what we don't see is the reasoning as to why this is a rare case. It must be a rare case for a company to be placed into liquidation. It is the remedy of last resort in terms of a shareholder dispute.
Because normally one side buys the other out.
Yes.
Yeah, but he's rejected the idea, has accepted your submission that your client shouldn't be required to sell to Madame Yao.
Yes.
So that's not available.
Yes.
The alternative hasn't been put on the table by anyone. And so what has been put on the table is a winding up order.
But I know my Lord has already, I think, made an observation about my submission on this, but it shouldn't be for my client to say, please make me buy out Madame Yao. I'm saying...
Well, you could, couldn't you? I mean, for all the reasons we've given, this petition is ill-founded and should be dismissed. All the allegations of fact should be rejected, and you've heard us at length on that. But final position, if you think something should be done and you really think that a winding up order is appropriate, then don't do that. Order that we buy Madame Yao's shares.
But the judge himself
that's what happens all the time.
The judge himself identified that.
I'm sorry?
The judge himself identified that.
What, that you buying Madame Yao's shares?
Yes, he said that's an alternative remedy they could do, and I'll bring you back. But he
maybe
didn't then
he
explain in
assumed
99 and 100 why he felt that was no longer something that he should even consider.
Perhaps he assumed that the reason why you weren't pushing or presenting that as an obvious alternative was that Madame Kwok didn't have the money to buy it.
That absolutely was never any basis for that to even be considered. There was never any suggestion. There was never any reference to Madame Kwok's financial
Or
position.
did you ever say that she has the money to buy out Madame Yao's?
I can't recall it being raised at all. I most certainly advanced the proposition that Madame Yao did not have the funds to meet.
No, it's whether Madame Kwok...
No, I understand that. But the point I'm making, I don't recall it ever being suggested by anybody that Madame Kwok did not have the funds if such an order had been made. And so I don't think there was any necessity for me to say she does have the funds, because I don't think it was ever suggested that there was an issue on that.
Well, you weren't going to suggest it if you weren't putting it forward as an alternative. But, I mean, my reading of it is that it was a tactical decision. You decided that you were going to say it's an all or nothing, and if Madame Yao can't make good her assertion that the most unusual order, which is that she should buy out your client's shares, which would be most unfair, and it's not an appropriate case for liquidation, then so be it. She falls by the sword.
Well,
and that's it. And you didn't put it on the table as even a point to argue.
it was raised twice, and I did not say at any stage that was not a possibility. What I said was, Madame Yao is the person who adopted a tactical position. She is the one who chose as her primary remedy to pursue a remedy that did not have any prospect of success. That was to then present the judge on her approach to a choice of, do I dismiss the claim on her approach? Do I dismiss the claim, or do I put it into liquidation? And that's what we say was tactically inappropriate, because she was advanced. If she'd simply gone with just an equitable without even considering an unfair prejudice remedy, it would have been very obvious that that was wrong and inappropriate.
Mr. Chasty, you took us this morning, and I've just reminded myself of what you said at page 7169, and you made it absolutely clear that you did not want an order that your client buy out Madame Yao. I mean, it could not be clearer.
I think I made it clear that
I said, I therefore repeat again and make the point as strongly as with respect I reasonably can, that it would be totally wrong at this stage to even be contemplating making an order that my client buy out Madame Yao if you were of the view that there was any unfair prejudice which otherwise justified such an order. And then you went on to say, but in circumstances where neither party asks for an order that we be required to buy out the claimant, it would be an extraordinary position for the court to impose an order that neither side are asking for.
Yes, and that's why he should. It's the claimant, the petitioner, left it too late to try to adopt that fallback position. She was the petitioner, not me.
Yeah, but she wasn't adopting it. She's not asked. She never was asking for an order that her shares be bought by Madame Kwok.
I agree. But it doesn't mean that it was incumbent on me to avoid liquidation by saying, please now let me buy.
No. We've probably taken this debate as far as we can.
Well, it is important. I wouldn't accept that my client was adopting an inappropriate tactical position when she was being faced.
No, I'm certainly not suggesting that. All I'm saying is that what was on the table did not include an order that your client buy Madame Yao's shares.
I accept I did not volunteer that as an alternative.
It goes much further than that. You said it would be quite extraordinary for the judge to do it.
At that late stage, that is right. At that late stage, when the petitioner had she had chosen to present the judge with this choice of an unlikely order, impossible order, or liquidation.
Yeah.
She should not gain an advantage, is what I was seeking to make. She should not gain any advantage. And that's why the liquidation order is, in our submission, irrational. And there is no proper reasoning behind it. He took into account, or you can reverse it the other way around, he did not take into account, in our submission, certainly did not explain where he'd taken it into account, that for example, the 2045 contract that he placed reliance upon was a commercially justified transaction. although he makes reference to it, he does not explain in part his reasoning to place the company into liquidation, that he didn't find that Madame Yao wouldn't have consented anyway. He doesn't take into account, or certainly doesn't explain again, that the cooperation agreement was entered into in 2009, years before. Although he touches on late cheese, he does in a different context. Nor again does he explain why it's not a factor to take into account that he doesn't even know if Madame Yao would have agreed to it or not. So we certainly identify factors that he failed to take into account and factors that he ought to have taken into account and failed to do so. And really we criticise as much the petitioner as the, if I may respect say, the trial judge, in that what they presented the trial judge with was this choice of make Madame Kwok buy or put the company into liquidation. And it's not, in our respectful submission, entirely correct to suggest that it's all about my client not saying she would buy. Madame Yao did not want to sell. It was Madame, it's to be looked at from both contexts. It's not simply me saying, I don't want to buy Madame Yao at this late stage. Madame Yao did not want to sell.
Well, then if she didn't want to sell and you didn't want to buy, why does the judge need to give it a moment's further thought?
Because because then otherwise she had no justification. If she wanted to come to a remedy, the court could impose on her the normal unfair prejudice remedy. It's not a matter of her choice.
What's wrong with liquidation as a reasonable remedy?
Well, of course, the court is told straight in the Acts, in our legislation and in the BVI legislation, that you don't place a company into liquidation on a just and equitable ground if there's an alternative reasonable remedy.
There isn't.
Now, well, it's Madame Yao who is saying.
Well, I still don't understand what you say was the reasonable alternative remedy that the judge should have imposed in this case.
He should at least have brought us back then.
This is a procedural objection taking
it's
now.
It's not. He was placed in a difficulty because of Madame Yao's approach, which is she did not want to be brought out.
Sorry, Mr. Chasty. He's made an order which you say was the wrong order to make. There's nothing to do with whether someone should have been called back and they were denied an opportunity of making submissions and so on. What order, you say it was the wrong order to make? Because he should have made what order?
He should have made no order.
Even though he's found unfair prejudice, he should not make any order.
Based on the approach that the petitioner was presenting to.
Yeah, all right. So,
yes.
So based on what the petitioner sought, he should have made no order.
Yes, because what the petitioner was doing was saying to him, I'm coming to you.
But that's not an answer to my question. Why is a winding up order the wrong order?
Because no order isn't a reasonable alternative order within the meaning of the legislation.
It is when that's how the petitioner has presented the options to the judge.
He's presented an option. What's wrong with that option?
Because the proper order should have been,
the proper order,
contrary to what he told me, he was contemplating making a winding up order, then he ought to have made an order that my client barred.
That, at least we have it. So the proper order he should have made was an order that Madame Kwok buy Madame Yao's shares at a valuation. And you would have consented to that if it brought you back and said, I'm going to make an order, what order do you want?
He didn't need my consent to that. He could have imposed that on me. That's what happens every day of the week in an unfair prejudice. You don't need to consent to having an order.
No, you certainly don't. But you, if asked, you'd have said, well, that's the right order to make.
If I'd been told, if I'd been notified and consulted and been told, I'm going to place this company in liquidation unless you're telling me that you're prepared to buy out Madame Yao, then that obviously would have been something that would have had to have
This is a sort of procedural objection, really, that the judge You weren't. It was not a sort of proper procedure. He should have brought you back and given you that, or told you this is what I intend to do. Do you say there's some other better order?
It goes beyond a mere procedural thing, because the judge is compelled to consider in the statute whether there is an alternative reasonable remedy to a just and equitable.
Yes. But no order isn't an alternative reasonable remedy.
It depends on the context in which the judge is being asked to exercise that discretion. And if it's the petitioner who's chosen to prepare to provide the battleground and saying, I want the company for myself, or I want the company to be put into liquidation, then I say that the petitioner shouldn't gain any tactical advantage.
But Mr. Chastity, the
Mr. Chastity,
clue lies in the word remedy. If you make no order, there is no remedy. So what my lord has put to you must be right.
Yes, I accept that.
Okay.
But I say that that's the consequence of the petitioner.
Well,
but
I'm conscious of time, Mr. Chase, but I think we need to move you on to the...
I'm just going to move on to the fresh evidence.
Exactly, because that's got a number of thorny little points in it on which we very much would like
I'm going to do this quite quickly. In fact, I hope. You've got our written submissions on that.
We have.
Insofar as the Court of Appeal's decision not to admit the fresh evidence is concerned, it did so quite clearly on one basis of saying that it was exercising its discretion by refusing to admit that evidence. And just so that you know what happened on the day, it was rejected, the application was rejected, because we didn't have any argument on the basis of, well, if we allow the evidence in, let's have a look at it. It wasn't admitted to bene esse. There was no further argument, so we didn't get into the detail in terms of analysing where that might take us if it was let in. So the Court of Appeal refused the application, and we all proceeded on the basis that it wasn't going to be admitted, and there was no then further argument about where might it have taken us. Now, my friend has fairly said that whilst there are some points not disputed about this fresh evidence, there are other points that most certainly are disputed, and that would be highly important, and it's what the Court of Appeal was concerned about. So the way that it worked was, just to try to recap as best I can, partly from memory, is an application was made for injunctive relief based on the evidence that was then being described as the fresh evidence to the Court of Appeal. We put in evidence in response to that, quite extensive evidence, which I'll mention in a second. The judge had not made a determination on that by the time it came to the Court of Appeal. Before the Court of Appeal, there was very little reference by Madame Yao about that history, about the fact that there'd been these exchanges. There is a substantial amount of evidence that was put in for the injunction application in response to the points that were being made. And the points that were being addressed on behalf of Madame Kwok were to the effect there was a commercial necessity to do what was done. It was justified commercially, there was no alternative. Bank pressure was such that it had to be done. If it wasn't, then it would be the end, because there was no other approach. And there's an accountant's report from RSM where they set out in some detail an analysis of the transactions that were being complained about, and expressed the view that in fact the transactions were for the benefit ultimately of the company in the way that the transactions are being constructed. Now, what the Court of Appeal rightly said in our submission is they couldn't start to carry out some kind of analysis as to those issues that were being raised as to commercial necessity, justification, absence of harm and prejudice as such. And the difficulty is that if you're going to throw something in, and it's a bit like what I've been saying before, if you're going to throw something in and say this is an issue of unfair prejudice, take it into account. You can't take half of it into account. You can't just say, okay, there wasn't a consultation or a notification, so we'll take that into account. You'd have to have at least the whole picture if you're going to start to trespass into that area, because it might, unfairness, and this does go to unfair prejudice, is something unfair if in fact it's got a commercial justification to it. It has to be prejudicial and unfair. There's two parts to that.
Well, this was a transaction which resulted in Madam Kwok getting a direct personal shareholding of 22% in the underlying Chinese company. So it was a transaction that conferred a direct personal benefit on her. One would have thought that was precisely the sort of arrangement where a duty to consult and obtain consent should apply.
My point, though, is this, that there was a massive evidence about the circumstances in which that consequence came about.
Well, it was a commercial necessity that she should get a personal 22% shareholding in the underlying Chinese company.
I appreciate that, with the greatest respect, that's a statement that can be made, but the whole of the evidence which was put before the trial judge for the purposes of the injunction is detailed and extensive. The Court of Appeal, in its discretion, said, we're not going to get into this. It's not for us to try to, A, evaluate that evidence ourselves, and then B, try and second guess what the trial judge might have done with it. And we say that was a perfectly understandable and legitimate approach of the Court of Appeal to take, and say, we can't get involved in that kind of thing now, because the petitioner, of course, wasn't in the normal position of a losing party saying, I've got this fresh evidence that shows I shouldn't have lost, and so I want a retrial. That's what you would normally probably do with fresh evidence coming in. You'd be the losing party. You'd say, here's a whole massive evidence that if the trial judge had had it, it could have made a significant difference to the outcome and I might not have lost. And so you would normally be expecting to say to the Court of Appeal, please admit it, look at it, and at least remit it for a fresh trial again.
Well, isn't there an additional reason why fresh evidence might be material in this context? You were seeking to overturn the exercise of discretion as to remedy under the Act. And if the Court of Appeal was with you, it would fall to the Court of Appeal in the first instance to decide what remedy, alternative remedy, if any, to grant. And in that context, it would be expected to do so upon the facts as they were then, not the facts as they were at the time of the trial. Now, why is that not a potentially quite weighty reason for updating matters to see, for example, in the context of an alternative policing remedy, whether there have been further instances of the same matters?
I think if the Court of Appeal by that stage was with me before it considered the fresh evidence and said we're minded to overturn the decision, if it then said, and we can see there's some fresh evidence, then it should have remitted it effectively. Let the trial judge look at everything and decide whether he wished to restore his order, not for the Court of Appeal to try and do it in circumstances where none of us had the chance, sensibly or realistically, to argue all the to and fro, as it were, on these new allegations.
I accept that in such a situation an appellate court has a choice whether to grasp the nettle or to pass the poison chalice back to the first instance court.
Yeah.
But without accepting and letting in the fresh evidence, how can it even make that choice?
Well, it decided in its discretion that it wasn't going to try the impossible in our submission, which was look at everybody's arguments about this evidence and try and reach a conclusion. It took the view in its discretion that the proper course was not to get into that because it couldn't reach conclusions, and it was entitled in our submission to do that. And it can't be said that the Court of Appeal was behaving irrationally in any way. If that was an exercise of its discretion, that's got nothing to do with the trial judge. It came to the Court of Appeal. The Court of Appeal considered it carefully, reviewed the authorities. The reasoning in our submission is quite clear and detailed on this, and perfectly understandable as to why they took that view. The last couple of points, it is clearly an interlocutory decision. Whether or not to admit fresh evidence, wherever it was heard, whether it was part of during the day of the main appeal or not, it was an interlocutory decision.
And if it was, does that mean that you would have to get leave on the point of general public importance?
We say yes.
Yeah, it's not that there could be no leave, but you'd have to pass the general public importance test.
Yeah. And the final point really is quite clearly the Court of Appeal did not decide to give permission on that basis. It gave permission in respect to the overturning of the decision of the trial judge, not the refusal of the Court of Appeal to admit fresh evidence. You can see, my friend again very fairly showed the slightly unclear, with respect, approach that was being taken to the Court of Appeal.
Well, it came here as an appeal as of right.
Yes.
Yes.
But that's not what the Court of Appeal gave. There was no consideration of any points of public importance. And as I say, I think that the point was made that it doesn't matter when it was heard, it is what it is, and it self-evidently is an interlocutory application.
But if it's got here under a false pretense,
Well, then it shouldn't be sent.
is it open to the board to consider whether there's a point of general public importance that makes it appropriate to consider it?
I'm sure that must be right. But I wouldn't invite you to engage in that exercise. And if you did, then admitting if fresh evidence is going to be a matter of great public importance, then I'd say.
Well, I was thinking really of
I
was thinking really of the point the 2 points raised by Mr. Chu Choi. One, whether indeed it's in this context an interlocutory decision for the purpose of the rules about permission to appeal, and secondly, whether the Court of Appeal were right to say that only that respondents can't bring in fresh evidence.
Yeah. Mr. Choi's made his points about that. If you look at that paragraph, I'm not myself. Wouldn't accept they went necessarily that far, but I can see that they were stressing. They were stressing it was a strange position to be in. But really, what I'm relying upon is not so much that point as the discretion exercise.
Okay.
I think that's my time up.
Thank you very much, Mr. Chu Choi.
As brief as I can. I think the board went through 3 sets of references for me. I've got 2 parts, essentially. First, there was a passage at paragraph 19 of the first instance judgment, which referred to Mr. Fisher partly relying on the cross-examination of the defendant on the 5th and the 6th of December 2017. So just to be clear, the actual cross-examination of the defendant on the 5th and the 6th of December 2017 is to be found at page 6415, lines 9 to 22. That's for the 5th of December. For the 6th of December, it's page 6438, line 20, page 6439, line 20.
That whole page.
I beg your pardon?
6438, 20, all the way through to 6439, 20.
Yes.
Yeah, thank
6438, line 20 to 6439, line 20.
Yeah.
And the second question I was asked about is where in the Court of Appeal transcript of the oral argument Mr. Fisher had stated that had answered a question to the Court of Appeal, which was recorded in the Court of Appeal judgment as being Mr. Fisher saying
No evidence.
No evidence.
Yes.
Unfortunately, contrary to my understanding or assumption, the Court of Appeal transcript is not in the reproduced record. So I'm afraid we've not, in the time available, been able to find that reference.
Okay.
But no doubt we could find it afterwards if need be. The third question I was asked was where in the re-amended statement of claim one is to find the complaints in relation to the question of failure to match funding. And the answer is paragraphs 84A to 84G at pages 322 to 324.
That's in the pleading.
That's the pleading, yes.
Yeah. Thank you.
Turning to my substantive points, one of the questions related to how failure to match funding might be relevant at all to the question of relief. 3 short points on that. Madam Kwok's failure to match funding was found by the judge to be one of the grounds of unfair prejudice. The liquidation order was sought as relief in response to unfair prejudice found by the judge. The nature and scope or scale of the unfair prejudice may potentially be relevant to the question of relief. But moreover, if there is an obligation to match funding, but for instance a risk of a subsequent breach of that obligation, it's not difficult to see how that could potentially strengthen the argument for a liquidation order. But I accept that whilst conceptually that is possible, I accept the judge did not actually say so in his judgment. But this is as far as I think I can realistically take it as to the potential relevance of failure to match funding as regards the form of relief. Mr. Chasty raised a point based on Section 1673 of the Insolvency Act, which correctly, which I acknowledge, requires the court, before making a liquidation order, to consider the existence of alternative remedies, and in particular alternative remedies that it would be reasonable for a claimant to pursue. As has been explored at some length already, the position the parties found themselves was rather unusual. The obvious alternative remedy that is pointed to by Section 1673 in this case is plainly an order that Madame Kwok buy out Madame Yao. We don't accept that the Court of Appeals order is a reasonable alternative remedy for this purpose. But what Madame Kwok has failed to acknowledge, we say, is that she has throughout the proceedings vigorously resisted an order that she buy out Madame Yao. We've seen some references already, including to the oral submissions of Mr. Chasty. Can I give you one additional reference to Mr. Chasty's written closing submissions at trial? Paragraphs 81 and 89 at pages 3111 and 3114. And it is also relevant to consider Madame Kwok's approach on the appeal at page 3175, paragraph 36 of her skeleton argument, where she studiously avoids any suggestion that the appropriate order might be an order that she buy out Madame Yao. There is even more vocal opposition to that possibility, as you may recall, in the written case for this appeal, which is paragraph 104 at page 7770. And of course, we can all see what is going on here. Mr. Chasty wishes to rely, or he wants to be able to say, a liquidation order is an extreme form of order. It should not be made, but simultaneously he doesn't want there to be an order that her client buy out, and he wants to produce, therefore, this artificial situation where essentially the only choice is a liquidation order which he can depict to this court, and which he depicted to the courts below as being completely irrational, and on the other hand, nothing.
Well, I'm not sure he goes quite that far. He certainly made that submission, but I think his fallback is that if that was not going to be acceptable, then he should have been able to opt for the middle course.
Yes, he did say that. But what is important to bear in mind here in my submission is it would have been perfectly legitimate for the court at first instance to take account of the fact that neither party wished to have a buyout order that was against them.
But that is the point Mr. Chastey made in oral submissions.
Well, and indeed, and if it's quite hard to see why that would be an irrelevant consideration for the court to take into account. And if it is relevant, it's not difficult to see how that could, obviously looking at all other circumstances of the case, and assuming they all point in the same direction, it's not difficult to see how the judge might fairly and justly conclude that the appropriate order in the particular case is an order for liquidation. Yeah. And of course, the reason why, of course, one might always recoil when hearing of a liquidation order in the normal case is when you're talking about the liquidation of an underlying business. Yeah. The big difference here is that we're talking not even of the liquidation of the immediate holding company. We're talking of the liquidation of the company higher up. And what liquidation will really mean here is that someone, at some point, for a particular price, will buy shares. The only difference will be they will be buying the shares of the only asset of Crown Treasurer, which is the shares of the intermediate holding company, as opposed to if you had a normal buyout order, where you'd have an order that the shares of Crown Treasurer itself be bought out. So in terms of form, in terms of legal form, actually both orders ultimately will result in a buyout of shares at the higher level above the business. And one might think that from a commercial point of view, actually there's not much difference between the two outcomes.
Well, the difference is you don't then have years of litigation about the valuation of the...
Well, absolutely, and there are pros and cons too, as Lord Briggs mentioned to me. If we were stuck with what we want, which is the restoration of the judge's original order, one potential downside, subject to what the liquidator does when he's appointed, is that the kind of order you might get with a straightforward buyout, where the buyout is to be on the basis of evaluation, ignoring the unfairly prejudicial conduct, is not going to be an immediate benefit that will inure to our advantage. But that's the consequence.
And as you say, well, the only wrinkle on that is that the liquidator might take up his own cudgels in relation to some breach of duty to the company. But of course, this case is all about breach of equitable considerations between the shareholders in relation to transactions which may have been perfectly okay vis-a-vis the company.
I quite see that too, and there may be complications as well in terms of the actions having been taken at different levels of the corporate structure. It could be quite complicated. Liquidators wouldn't take action without being funded, etc., etc. So it's a long way down the line, but our position on the appeal is nevertheless clear. The complaint that the judge essentially failed to make extensive findings and to use those findings in relation to matters that were no longer relevant for the purposes of justifying the findings he did have to make in relation to issues that remained relevant is, in my respectful submission, somewhat unreal. The judge at paragraph 17 to 18 recognized the fact that a number of allegations had been abandoned, a number of claims were no longer being pursued. It would have been therefore obvious to him that a number or certain aspects of the claimant's and her husband's evidence in relation to those abandoned aspects was not being maintained or being withdrawn, or may even have appeared to him to be not very credible. But there is no reason to suppose that he was not aware of that, or that he did not take that into account. He was very careful to state in paragraph 34 and to 36 that he was taking account of all of the evidence, all of the witness statements, that must mean those parts of those documents that were no longer being pursued. What is also relevant is that there was no appeal by Madame Kwok to the Court of Appeal on that particular ground. There was no suggestion that the judge's judgment was flawed at first instance because he had failed to take account of the effect of the abandonment of allegations. That was not a point that was pursued, which is why it's not a point that is commented upon in the Court of Appeal's judgment. So to try to make a huge point of it now is, in my respectful submission, rather late and shouldn't really fly. But there's an even more fundamental problem with the approach that my learned friend is taking to the supposed significance of abandoned allegations and abandoned evidence, which is this. The relevant question is the one that we summarize at paragraph 26.2 of our written case, which is whether there is reason to suppose that the findings of the trial judge cannot be explained by virtue of the advantage that he or she had as a result of seeing and hearing the witnesses, at least in the kind of case where there is a direct conflict of evidence on something that's not documented. And if you ask yourself, well, does the fact that the judge has not commented on lots of allegations and claims that are no longer live, does that mean that the advantage that he prima facie would have had as the trial judge, who'd seen and heard the witnesses on the points that did matter, had that advantage disappeared? Or was there a reason to suppose that he was no longer enjoying that advantage because he didn't comment on allegations that had been abandoned? And the answer is, well, no, of course not. The advantage was there, it remained there, and it would undoubtedly have stood him in good stead in relation to the findings that he did make. The two very small points. My learned friend embarked upon a fairly wide-ranging criticism of the judgment and the supposed absence of reasoning. But one of the points he made was in relation to the 160 million, and he said that there was no identification by the judge of the nature of the 160 million. But of course, you will bear in mind paragraphs 55 to 58, where he did make a finding as to what he thought was the nature of the 160 million and how it should be treated within the company. And moreover, you will recall that in paragraph 56, perhaps in a slightly more detailed explanation of the process whereby he went about making findings of fact in relation to whether oral agreements had or hadn't been made, he says, in relation to the so-called Fuji oral agreement, having reviewed the evidence and observed the demeanor of Mr. Tung on cross-examination, I find that there was a Fuji oral agreement. Very, very brief, but nonetheless, none the worse for that in my respectful submission. And there was certainly no complaint from my learned friend as to the appropriateness or correctness of that finding.
I'm conscious that even this way o'clock, reaching 4 o'clock.
Well, my lord, I have 4 more points to make, if I may.
You better be pretty quick.
Yes. You've got the point that paragraph 41 has got to be read in the context of what precedes it. Likewise, paragraph 34 of Madame Yao's statement has got to be read in light of what followed, what preceded it. On delay, latures, a couple of references. There was an explanation of why there was delay. The claim was begun in 2013, and one of my learned friend's complaints was, well, the liquidation order was made in 2018, whereas some of the underlying transactions that were being relied upon as being the source of, as justifying the liquidation had been entered into in 2010. Of course, what he has not referred to is the fact that there was litigation in the PRC in 2010 in relation to the cooperation agreement. And that's referred to at paragraph 45 of Madame Yao's closing submissions at first instance, pages 3135 to 3136. And moreover, in Mr. Fisher's oral closing submissions at page 7046, line 23 to 7050, line 26. Sorry, line 16. Final point, my learned friend's reliance on the would have point, the construction point as to paragraph 34. I've already made my point about how paragraph 34 should be read, but the Court of Appeal did not make any finding that there was no evidence in the case to support the agreement alleged by Madame Yao on the basis of a proper understanding of what would have means in the relevant witness statements.
Thank you.
And I believe that's all I have to say.
Very well. Well, the board is most grateful to counsel on both sides, and no doubt their supporting teams for the trouble that's been taken in presenting these submissions. And the board will take time to consider what advice humbly to tender to Her Majesty. His Majesty.